For today's story, we are talking about a proposed amendment to the Constitution, the Equal Rights Amendment, which is dead. Or is it? As an appeal court in D.C. tries to struggle with whether or not the proposal is still viable or not. So the Equal Rights Amendment is a proposal to the Constitution. That would be the 28th Amendment to the Constitution, which would prohibit discrimination on the basis of sex explicitly. What it would do as a practical matter would be to elevate sex-based scrutiny from intermediate scrutiny, where it is now, to strict scrutiny, the same as race. It would prohibit any sort of discrimination by the government or any of its entities on the basis of sex, unless it could meet strict scrutiny, which is basically borderline impossible. This incidentally would swing both ways because it would prevent any sort of thing that would harm or benefit either sex on the benefit of sex. So it would be really interesting to see if this actually went into effect, what the practical consequences would be, because I think a lot of people on the progressive side who have been wanting this amendment, if it actually became into be, would be a little bit surprised by how it would actually function in reality, because they would see a lot of benefits that seem to be sex-based, that seem to be pro-women, would suddenly disappear because they would all be unconstitutional now. That's the nature of amendments. They tend to be a nuclear bomb and just upset everything. But anyways, what its practical consequences are not our immediate issue. Our immediate issue is it still a thing? So the DC Court of Appeals has been asked to decide, at least in part, whether it's still a thing. So let's go ahead and get started with this. A panel of federal judges has expressed skepticism about two states' efforts to enshrine gender equality. And right away, I'd like to note that's wrong. It's not gender, it's sex. I can read the text. In the U.S. Constitution, by getting the federal government to recognize the Equal Rights Amendment decades after it was considered dead. At a hearing Wednesday before the United States Court of Appeals for the D.C. Circuit, Illinois and Nevada sparred with the Justice Department over whether ratification of the proposed constitutional amendment, long after congressionally set deadline to do so had passed, should count for something. So in the preamble to the amendment that Congress passed, they put a deadline for ratification. That deadline has long since passed. Now, in some of the constitutional amendments, they actually put the deadline in the text of the amendment itself. But for the Equal Rights Amendment, they didn't put it in the text. They put it in the preamble to the legislation. That was the legislation to make it thing. So I suppose one of the questions the court has to deal with is there a legal difference between putting in the text of the amendment and putting it in the preamble to the amendment? So that's one of the things they're dealing with. The states are arguing in part that the deadline Congress set for ratification as part of the preamble to the amendment is an unconstitutional encroachment on state power, because it would artificially limit their ability to pass the amendment. But Congress is the one that proposes amendments, or at least one of the mechanisms is the mechanism we've used. There is, of course, the Convention of States. We never actually use that mechanism. So the Congress is the one that proposes it, and they can propose deadlines, and they have in the past, at least in the text. A lawyer for the Justice Department countered that while the Biden administration agrees with the principles of the Equal Rights Amendment, the executive branch can't unilaterally decide whether it's part of the Constitution. I mean, there are rules. Our ratifications have not been given their intended effect, said the Solicitor General of Illinois. Well, the problem is, of course, the ratifications were not sufficient because there weren't enough signatures within the deadlines. The three-judge panel of the appeals court appeared open to the idea that states had the legal right to force the United States archivists to certify and publish equal rights amendments, which is incidentally one of those little curiosities of U.S. law. Like, who gets to decide whether an amendment is part of the Constitution or not? Well, Congress passed a law, and the law says that the archivist of the United States, that is the head of the National Archives, is the person who decides whether or not an amendment has become law. That's just who it is, right? So if you want to know whether an amendment is the amendment or not, you go ask the head of the National Archives, because that's what the statute says. They're the one that gets to decide. So they apparently want to be able to sue to force the archivist to say this is part of the law. But the Department of Justice seemed less sure the position was right, and that the amendment, which is proposed by Congress, but of course needs ratification from 3/4 of the states to become the law, and within the time frame, which has long since expired, has in fact become part of the U.S. Constitution. The legislative history seems to indicate that Congress only passed the Equal Rights Amendment because it did have this deadline. I mean, it is part of the preamble of the thing. It's one of the things Congress wrote, said the judge. If the deadline wasn't allowed, wouldn't then the result be to invalidate the entire amendment rather than just invalidating the deadline? So it's like, if Congress can't do this, maybe the entire thing was void ab initio, which, would be basically the same result anyway. The states disagreed, arguing the deadline in the preamble was simply unenforceable. Why? I don't know, because Congress is the one that proposes the amendments. They can propose to require them to ratify them within a certain time period if they want. And some of the amendments have it in their text. Here, they didn't put it in the text. They put it in the preamble, which is a little bit cleaner. And they're saying, well, there's a legal difference there. I'm not quite sure about that. Judge Nemo Rayo suggested the state's interpretation seemed to take us way down a slippery slope in terms of undermining Congress's ability to propose amendments, which is pretty much absolute. There's only one thing that Congress can't propose, that the nature of the Senate, in terms of the nature of who sits in the Senate, is changed, right? They can't deprive any state of its equal representation in the Senate. But other than that, they can do anything. That's the nature of amendments. It's a big explosion that can do just about anything. And so, why can't Congress put limitations on how long the states have to consider this? There's no possible reason. Sarah Harrington, an attorney for the Justice Department, said the Biden administration supports the principles that are espoused in the ERA. Again, if this ever actually became an amendment, I wonder how the progressives would feel about it. Because there are a lot of things in this nation that are explicitly structured to help support people on the basis of sex, usually women, right? The Violence Against Women's Act, for example, or any number of state-based scholarships from public universities for females, or whatever, right? It's like, okay, if you're now elevating sex-based scrutiny to strict scrutiny, how many of these things are now constitutional? Is Title IX even constitutional or not anymore? I don't even know. Because it's a big explosion that undoes everything. I think in balance, if this ever actually became a thing, the progressives would rue the day it became a thing. Because I think on balance, they would find it would hurt them more than help them. The ERA was considered previously expired when it fell 3 states short of the required threshold for ratification, failing to meet the original deadline of 1979, and then a 3-year extension. 5 states since then have also withdrawn their approval, so then you have to get into whether or not those withdrawals count or not. If signatures after the date count, do withdrawals after the date count? So how do you get into that issue, right? So, okay, so that's a whole counting problem. The House, but not the Senate, had previously passed legislation to remove the deadline, which, because it was part of the original preamble proposal, you get into issues about whether or not that's even constitutional. It's like, because the original proposal had the deadlines, like, can Congress change that by mere legislation? All kinds of fun legislation questions, right? You can put a deadline in the original proposal, but if some states sign off on it with that deadline in mind, and then you change it after facts, like, wait, can you do that? Because, like, are you changing the proposal in some ways? All kinds of fun questions. Supporters of the amendment take the view that the deadline and the withdrawals are invalid. So the deadline doesn't exist. And all the states who took back their ratification, they can't do that. Because deadlines are not in the amendment itself, they say that makes a difference, and ratifications are final, which there is some case law to support that proposition, but of course, all new questions when there's specific things in mind. Inspired by these arguments, 3 states ratified the amendments in the past 5 years, ending with Virginia, which would be the 38th state, if it was valid. To supporters, that meant it would go into effect this January, because that's when constitutional amendments would go into effect. They go into effect the next calendar year. But under the Trump administration, the U.S. archivist refused to certify, because they're the one who makes the decision. And so the person who was the leader of the National Archives said, no, I'm not going to ratify this, or I'm not going to certify it, rather, that it was ratified, leading to this lawsuit. President Biden's nominee has said that they'll stand by the decision unless the court or Congress orders them to do otherwise. So they're not going to change that decision. It's not even clear that they can change the decision because of, again, it's a constitutional amendment and who gets to make the decision and when it's final, right? There's all kinds of fun questions. The Attorney General of Illinois, however, is convinced the 28th Amendment to the Constitution exists. I am less convinced. The challenge is if you're putting in a protection in our Constitution for discrimination on the basis of sex, like any laws, people look to the books to know they exist. There's meaning in publication. Yes, there certainly is. That's how amendments get notified. They get put in the Federal Register just like anything else, right? The official register of all the business of the U.S. government, right? So if it becomes an amendment, they put it in the Federal Register, and it's not in the Federal Register. So the Attorney General of Illinois thinks the amendment exists, but again, so many problems. The deadline passed in 1979 and then again in 1982. 5 states have withdrawn, or can they? 3 states since then have certified, or can they? So all kinds of stuff. Every other constitutional amendment with a deadline has been ratified within the time frame, so we've never had that problem before. A federal district court last year found while ratification effort is laudable, it's contradicted by a clear deadline. There's no doubt that Congress intended to be binding. So, you could always try again. You could always get those certifications again if you can. And also whether or not it's a good idea. It's like, yeah. While sex discrimination is protected under federal law, the ERA would subject laws that just differentiate between men and women to greater scrutiny. Yes, that would be the upshot. It would elevate sex-based discrimination from intermediate scrutiny to strict scrutiny, the same as race, which would prohibit any legislation from any federal, state, or local government that either tried to inhibit or promote any sort of benefit on the basis of race or sex on equal terms. So that would be a lot. Both advocates and opponents believe the ERA would strengthen the argument for a constitutional right to abortion. I don't see how, but okay. Arguments in the case occurred before January when advocates say the ERA took effect. Advocates in North Carolina asked time for the court to argue the court must consider the entire Constitution, which legally includes the 20th Amendment, but of course the Supreme Court said no. And I'm also not clear how it would change in any way, because it doesn't, just to say we're not discriminating on the basis of sex, but there's case law already saying that it's not discrimination on the basis of sex, and I don't think elevating the standard would change that, but that's a whole nother discussion for another time. Let's wrap that up. Thus, that brings us to the end of the case about the appeals court debating whether the Equal Rights Amendment is really dead or not. I think it is, because Congress has the ability to propose amendments to the Constitution, and they have the ability to put deadlines on those. And those deadlines have long since passed. Also, if it became a thing, I don't think, one, it would do anything to change the abortion cases, because I don't see how elevating the standard from intermediate scrutiny to strict-based scrutiny, strict scrutiny, would infer that there was a right to abortion in any of that. But okay, that's me. And also, I think it would wind up hurting people more than it would benefit, because it would get rid of a lot of sex-based benefits that are currently in place. So I'm not sure it would really do anything that they're proposing to do, but yeah. So at least for the moment, that brings us to the end of discussion of this case.